I just.
Yeah, I'm doing my meeting, so I'm gonna keep my
Camera on.
camera on.
Mrs. Gardner-Brown, you may want to mute your computer.
Thank you.
Still silent to you. I do not. Thank you, Gina. Good afternoon. Wednesday, the first day of December 2021, Court Commercial Court 2 via Zoom at 2:34 p.m. before Honorable Justice Sybil Williams. Criminal Jurisdiction 2018, number 4. The Queen versus Kyrie Smith Williams. Mr. Richardson for Smith Williams, Mr. Mahoney, and Ms. Karen Dean for the Crown.
Yes, good afternoon, Council. Good afternoon, Mr. Mahoney and
Afternoon.
Mr. Richardson. Sorry, who's the second prosecutor assisting in this matter?
The second prosecutor, milady, is Mrs. Shante Simons Fox.
Oh, thank you. Yes, I see Ms. Simons. Ms. Simons Fox?
Yes, my lady.
Thank you. Now, this matter is listed for trial starting on the 10th of January, which means that we are in urgent need of some case management hearings if it's going to proceed on the 10th of January. How are we situated?
Well, I received an email from our litigation manager, Ms. Kendria Place,
Yes.
which came from Mr. Vaughn Keynes, sent at 4:56 p.m. on Monday of this week. He addressed it to Mrs. Place. I don't know why I didn't send it to myself, since it's known that I'm the prosecutor in the matter, or even my colleague, Ms. Simons Fox. And Mrs. Place forwarded to me at 11:38 a.m. yesterday, in which I think the court may have a copy of the email that was sent.
I'm keenly waiting to hear what it is.
Very well. So it's this. Good afternoon, Mrs. Place. Further to the above caption, we as defense counsel for Mr. Smith Williams have not been provided with the unused material from his previous counsel, Mr. Lynch QC, and are requesting the same from the Crown. Additionally, though, we have been provided with some transcripts of key witnesses from the Court of Appeal. We submit this is incomplete. As such, we also humbly request transcripts from all of the witnesses from the Court of Appeal for complete.
Mr. Mahoney, can we do this a short way, please? What's the bottom line? What am I to take from all of that? What's the position?
The bottom line is that I took the liberty of reaching out to Ms. Sarah Tucker, and I am advised that the material that they have from Mr. has always been available.
I'm very confused. I understand Mr. Charles Richardson to be representing the accused. Am I correct in that understanding?
Yes.
All right. What does Mr. Keynes have to do with any of this?
Oh, Mr. Keynes is second chairman.
I was thinking.
Oh, I see. Thank you, Mr. Keynes. You are the. Oh, thank you very much. I just had Mr. Charles Richardson.
No, it probably was to do.
And whoever has their mic up, I think it's Mr. Wilson. Can you please mute yourself? You're disrupting this appearance. Thank you.
Yes, my lady. I didn't want to supersede my senior, which is why I didn't respond early. That's Mr. Keynes.
Yes. Yes. Thank you, Mr. Keynes. So Mr. Charles Richardson and Mr. Keynes appear for Miss Kyrie Smith Williams.
Yes, my lady. I am lead counsel.
Point. Thank you.
Mr. Keynes is assistant, yes.
All right.
May I continue?
Yes, thank you. Now,
Yes.
Mr. Mahoney, I have better context. Thank you.
Yeah, so I am advised that the material have always been available. All his current, the defendant's current attorneys need to do is to send an email requesting same, and they can collect it, or it will be delivered to them.
Can I just hear from Mr. Richardson? So that's a starting point. What's the issue?
My lady, the issue simply is this. You may be aware that this is a retrial.
Yes.
As a result of the matter going to the Court of Appeal. For the purposes of the Court of Appeal, a certain number of transcripts were prepared at the request of Mr. Lynch, who did the appeal. I had made it clear from the outset that I have those transcripts from Mr. Clado, but that I am aware that those transcripts do not represent the totality of the evidence given at the previous trial. I was asked if I could assist to indicate what other transcripts would be required, and I indicated I couldn't. I wasn't trial counsel. But my understanding is that when you have a retrial where the same witnesses are going to be called, it is customary, it is in fact mandatory that not the defense, I'm not even sure if it's the prosecution's duty, but that the court disseminates transcripts of all of the previous evidence, because there's no way I or any counsel are going to be able to determine whether a witness has given inconsistent evidence or be able to confront them with it. And I flagged this up earlier.
What I understand from you is that the Court of Appeal transcripts partly transcribe the trial process, the original trial. And there are some outstanding things that need to be transcribed and that has not yet been done.
Yes, my lady, you've gotten right to the nub of it, yes.
Thank you.
The Court of Appeal was centering on the issues around the main witness, Troy Harris. So the
what efforts have been, has there been communication with the registrar as to the transcripts that need to be prepared? I mean, this thing's been knocking around for a while, hasn't it?
Yes, I assumed that the transcripts would be coming. That's why I asked Mr. Keynes to write and indicate, look, just remind them we don't have all the transcripts.
Well, I'm good.
And the transcripts are more important than the unused material. Right?
Okay, let me, I could spend and maybe even waste time querying you as to why that's now just being raised. But I'm more interested to really come to where we are and where we're headed. So,
well, go ahead.
So you don't have these transcripts. It is your understanding that the transcripts have not even been prepared.
I don't know. They might actually be prepared. I don't know. That's why
Mr. Mahoney, that very narrow question. Have you ever seen any full transcript of the original trial?
No, because for the appeal, Mr. Lynch
He only went to certain parts.
Yes.
Right. Okay. So the other parts remain untranscribed, is the long story short.
That's it.
Okay. And the likelihood of that being done in the next week or two is dubious. And even if it was done, let's say that they landed on your desk in the next 2 weeks. How does that place us for a January 7th start? I don't want to beat around the bush. I have many matters and I want to really know what the position is.
My lady, I could probably be ready, but I can't guarantee it. I would have to see how many transcripts there are.
Well, I'm going to pull out that January date if it looks like it's not going to happen, because there are other matters to follow. And I don't want to get to January 6th just to observe the obvious.
I agree. I can indicate, my lady, that for my part, it would.
Did I not in previous hearings direct for the? I feel like this issue has been raised in previous hearings before me.
It was raised, my lady, and the question was whether or not we would require more. And I indicated then that once I read the summation, I would be able to see how many witnesses versus how many had been transcribed versus how many hadn't. And once I read the summation, that's when I realized, well, no, there's a considerable number of witnesses that haven't been transcribed. I can see why Mr. Lynch selected what he did, but the upshot is we don't have this.
So on the 21st of July, Ms. Richardson, you appeared before me. It was the DPP, Ms. Clark, who appeared for the Crown. And it appears from my note that there was not a confirmed position as to whether or not the trial had been fully transcribed. And looking from my note, the court's expectation was for counsel to make those inquiries. On the following court date, which would have been the 2nd of August. Let's see, Mr. Mahoney and you, Mr. Richardson, appeared before me. Let me see a version of this. I directed for counsel to be provided within a 7-day period. The court smart audio recording, but counsel were to obviously communicate that to the registry that that was the direction of the court. Do you have the audio records of the court smart audio for the hearing, for the trial?
I have received one, yes, Lady.
Okay. Let's see. I also directed for the transcripts coming out of the Court of Appeal proceedings to be sent to you electronically within a 7-day period. I
That
have
was
the
done.
impression that was done.
That was done. That was
All
done
right.
by Mr.
Okay.
Bailey, yeah.
And I also directed, although I remember commenting that my direction was not necessary, because if you wanted to access the court file, you would go through the registrar.
Yes, and we've done that. We've
And you've
done
done
that.
that. Okay. I just want to see exactly where we are. I can see not much has happened since. So this is an updated position then.
Yes. It may perhaps have simply been an oversight on everyone's behalf, but I would say that we can't properly proceed without transcripts of those witnesses, because neither myself nor the court is going to be in a position to assess whether evidence has been given which is different, and to follow the process and confront the witness with it. I can't confront the witness with the audio.
Right. So I just need to direct for full transcripts to be prepared.
I was going to say to the court, if the transcripts is probably the main thing I need. The unused material, I'm not so concerned
It's
about.
such a gross waste of time that that direction was not sought or made earlier.
It may not be, my lady, because I think we have another matter that can slot right into that spot, which is Taj Muhammad.
That's not on my list today.
No, it's not on your list.
Oh, that's not before me. That's before another judge.
For another judge, but
Okay,
we
all right, that's fine.
discussed this morning that if this matter didn't go, we would still
Okay.
be able to profitably
Okay.
use it.
All right, okay. Mr. Mahoney, do you want to add anything to this? I'm minded to vacate the date, but I think I should assign another date, or at least if I don't assign another date, I'll obviously set this down for mention again, probably in February as opposed to January, but I'm not adverse to putting it in my January list to see
May I make a
where we
suggestion,
are.
my lady? May I make a suggestion?
Yes.
Maybe, would it be possible to canvass the registry whether we could operate a simple knock-on? Because Taj
If you could,
Muhammad
what? I didn't hear you. If you could.
operate a simple knock-on, since Taj Muhammad may not go, and this matter may not go, and Taj may take its place. I have Palakai Williams following next. We could just move them and still follow each, and there'd be no gaps in the court's diaries, what I'm trying to say.
I only know, I'm only concerned with my list. I have to tell you, I can understand why you may think it's helpful to reference these other matters, but I have a fixed list, and my primary concern is to work through that list.
Fair enough.
So the fact that the court time opens up and another judge can hear a matter is good. I'm glad to hear it, that the court itself will not be just sitting idly, but that's not going to take me much forward right now in this moment. I am just, all I want to know is whether or not there's any issue with me from the Crown vacating the date, directing that transcripts be made, and setting this matter down for mention on February 1st. That's what I'm minded to do right now and move on to the next matter.
No issue.
Okay.
No issue, my lady.
All right. So that's my order. You will have to cooperate, I think. In fact, I'm going to direct counsel so that there's really no confusion about it, to communicate to the court that I have ordered for transcripts to be made, and to provide any assistance that the court administration may need in identifying what parts of the trial needs to be transcribed. I'm certainly not going to get involved in that process.
Okay.
Yes?
Fair enough, my lady.
Yeah, because you know better than anyone else what what needs to be transcribed and so forth. So provide, please, Ms. Gazard, presuming we're concerned with Ms. Gazard doing the transcription. Someone is going to need some specific outline as to what dates and what evidence and, what needs to be transcribed.
My lady, for the purposes of a retrial, every witness that the Crown intend to call.
I understand that, but you're saying some things have already been transcribed
Oh, yes, yes.
to avoid the double work. So we don't want her doing what's already been done.
I can do that, yes.
Thank you. Transcripts. So when is that correspondence going to be made? Because I want to give a direction as to when you should identify that and send that letter into the court.
I can go through the transcripts I have and indicate which witnesses were transcribed by the end of the week.
By next week, you said?
By the end of the week.
By the end of the week. Okay, so where are we?
That's Friday, day after tomorrow.
So Friday the 3rd?
Yes, my lady.
Okay, thank you. So by Friday, 3rd of December, defense counsel to write to court, copied obviously to the Crown, on what remaining portions of trial needs to be transcribed. And mention 1st of February 2022 at 2:30 p.m. by, I'm going to say by Zoom, and if these become appearances that's going to be in Sessions House number 1, then you'll be notified by probably Ms. Dyer, okay?
That's good.
All right, okay, so that's the matter for Kyrie Smith Williams. Can we have the next matter, please? Thank you,
My
Counsel.
lady.
Yes, thank you very much.
Grateful.
Wednesday, the first day of December 2021, via Zoom at 2:51 p.m. before the Honorable Sybil Williams, Criminal Jurisdiction 2021, number 11, the Queen versus David Curley and others. Mr. Pettingill for David Curley, Ms. Greeley and Ms. Warner for Christopher Clark, and Mr. Disman for Mr. Adderley and Ms. Gardner-Brown for the Crown.
May it please you, my lady. So in relation to the matter concerning Mr. David Curley, that is case number 11.
Yes.
And the matter in relation to Mr. Clark and Mr. Adderley, that is now 11A. In relation to 11A, my lady, I appear along with Mr. Javon Rogers.
Yes, good
I
afternoon.
am aware, my lady, good afternoon. I am aware that Mr. Richardson is holding for Mr. Pettingill in relation to Mr. Curley.
Mm-hmm.
My lady, Mr. Pettingill and I have commenced certain discussions, and subject to the court's approval, my lady, we would ask that this matter be mentioned for the March arraignment.
Yes.
Where we'll be in a position to indicate how we are proceeding at that time.
Okay. All right, the 1st of March is on a working day. I don't have my calendar up, let's see.
Yes, my lady, it's a Tuesday.
Right. So 1st of March at 2:30 p.m. Let me get the calendar up, 1 minute, please. All right, so that takes care of indictment number 11. Does that now move us on to 11A?
Yes, my lady.
All right.
Lady, may I be excused?
Yes, thank you, Mr. Richardson.
Thank you.
My lady, I would say that there are 3 things outstanding in relation to 11A.
I think I have a ruling that you're waiting in terms of the removal application.
Yes, my lady.
Yep.
Secondly, my lady, Mr. Desmond filed a summons seeking an order for disclosure.
Yes.
And thirdly, my lady, consequence on that and on
Sorry,
your
who filed that summons?
Mr. Desmond, my lady.
Okay.
I see Mr. White is on the line.
Yes, my lady, for the sake of the record, I appear today holding for Mr. Dismont.
Okay, thank you. Mr. Dismont's client is Mr.
Adderley, my lady.
Adderley. Thank you.
And my lady, consequence on those 2 things, we
Yes.
have the Section 31 application being pursued by Ms. Greening and Mr. Desmond, which was set for the 3rd of March. I am not sure if we would be maintaining that date.
Okay, I can see that in the court diary, yes. 3rd. So that disclosure summons, you would want determined, I would think, sooner.
Yes, my lady. My lady, I was wondering if the date that we had set for December 10 initially for the hearing on Mr. Desmond's now abandoned argument on the amendment to the indictment, if that date would be convenient to Mr. Desmond and the court.
No, I want to come out of December, please. I'm trying to come out of my December matters at this point, I have to tell you. But
my lady, the 3rd week of February.
let's see. I'm overseas on the 3rd week of February. What's that? The week of the 21st?
Yes, my lady.
And that is a week preceding. Actually, that might be feasible. Let's just see. 1 minute. What's the real difficulty in dealing with the Section 31 at the same time as dealing with the disclosure summons on the 3rd?
My lady, the Crown has no difficulty, but I'm not certain if Mr. Desmond is saying that this material that he believes he's entitled to would be something that he intends to use in his 31 application.
But the Section 31 application would be premised on insufficiency. So I would only be looking at the evidence that the Crown is relying on, as opposed to whether or not any unused material is, I would be surprised, put it this way, my starting point. Ms. Screening, are you trying to?
Well, just, we think the ruling in the application to have Mr. Warner removed would need to be determined first, so that if we're making our Section 31, we know who's making it.
Well, that ruling will come long before that. That's been argued, and you're just waiting for a ruling. That you'll likely get that ruling within the next couple of weeks. But come back to the disclosure summons, Mr. White. It seems to me that there would be it would be practical and even efficient for me to deal with the disclosure summons at the same time that I deal with the Section 31 application on the 3rd of March.
Yes, my lady, and I I take the court's point as regards the insufficiency of evidence being the test in the Section 31. Needless to say, I don't have immediately specific instructions from Mr. Dismont on that point, but I would very humbly submit that if we did set it down on that same date, if Mr. Dismont arrived at the decision or the belief that there was an issue, presumably he could administratively write in to the court and seek an earlier date.
Yes. Yeah. All right. So as it stands right now, I'm going to list the disclosure summons for to be heard at the same time on the 3rd of March next year at 10 a.m. And it seems to me that 10th of December date is now properly delisted.
Yes, my lady.
Okay.
So, my lady, the only thing remaining then would be orders in relation to filing.
Your what? Sorry?
The orders, my lady, in relation to when the defense should file their submission for the 31.
Oh, I see.
And the
well, I think before I can give those directions, maybe I can contain those in, give that direction in a cover, in some cover correspondence from the court once I give my decision on the removal application.
Very well, my lady.
Because it would be a strange thing for me to direct. I mean, Ms. Greening is, yeah, I prefer to do it that way. Let me just leave it at that.
Very well, my lady.
But I'll make a note. Directions needed. I should mention this matter before. I'm going to mention this matter on the 1st of February. Okay. So that we're concerned with 11-8.
2:30, my lady?
Sorry, 2:30, yes, thank you. And I expect to confirm those directions at that mention, okay? So my memory, in fact, I'll just make a note so it doesn't fail me. When directions to be given. Okay, can I move on to the next matter? Anything else?
No, my lady, that is the extent of my list. May I be excused?
Yes, thank you very much, Ms. Gardner-Braun. Thank you, Counsel. Thank you, Ms. Green, and thank you, Mr. White.
Thank you, my lady.
Wednesday, the first day of December 2021, Chambers before the Honorable Justice Sybil Williams, Appellate Jurisdiction 2021, number 20, Tatum Ford versus Vienna Meadow Police Sergeant Mr. Ford in person and Department of Prosecution Mrs. Sofianis for the Crown.
Okay, thank you. Ms. Sofianis, I do not see. Sorry, did I hear Ms. Sofianis for the Crown or is that Ms. Tweed?
My lady, I do not have conduct of that matter, but I will on behalf of my colleague. If it's just for directions, I will be happy.
Yes, it's just for directions. And sorry, who is the defense counsel? I missed that.
Mr. Ford is in person.
Okay, is Mr. Ford here?
I don't see him in person. I'm not sure if he was made aware of the change of the time and date.
I will direct for another date to be set on this. Ms. Aswood, I think.
I'm sorry,
Yes,
my lady, I don't mean to be interject, apologies, but I do have some information. I can just give me a moment, Ms. Baker
yes.
advised that it was mentioned on the 9th of December.
Yes, I think I brought those matters forward.
She said we did not get a notice of it being brought forward, so we would not know.
Okay, well, let me then formally adjourn it, as that seems to be the theme with a few of the matters to come. I think the court administration has really been overwhelmed, so it doesn't surprise me if notices were not fully sent out. Let's see. Miss Tweed, is there a record that you've received for this? Oh, actually, it looks like I do have a record. It's a very small one.
I wouldn't have it as it's my colleagues, so I cannot.
Okay. Well, if I have it, then the presumption is that the Crown has it.
Absolutely.
Can we be efficient and just set a date for the hearing of this appeal, and then you can inform your colleague, and we can send a notice out to the appellant,
Will do.
who probably would be expecting on the first appearance to argue his appeal anyway.
Okay.
All right. So let me see if I can give this a quick date. 1 second. So I've got some space in January. I can see now that's been freed up. So I can set this matter down for, let's see. Set down for Friday, 7th of January.
I'll take that on behalf of the Crown.
Okay, thank you.
That it does not work with right in.
Appeal. I'll set it down for 10 a.m.
I'm guided. Thank you.
Does not look like this is the kind of case where I will be giving out any directions. We've got a litigant in person and you'll be required to respond. So I am not minded to give out any directions for filing of arguments.
I'm guided, my lady.
But what I would ask is whatever is the relevant statutory framework for my consideration, that a copy of that be provided to me by the Crown. Only because I would not want, I think there's quite a few regulations that were circulating about, and I don't want to be confused about what is the correct set of regulations to look to. So I'll rely on the Crown, please, to provide that at the hearing.
Yes,
I'll just make a note. So Crown to provide relevant statutory framework is how I'll put it. All right.
I'm guided.
Thank you. And obviously I'm directing for a notice of hearing to go out to Mr. Ford. Okay, thank you. So we can call the next matter. Thank you very much, Ms. Tweed. What's the next matter, Ms. Oswood, please?
The next matter, Wednesday, the first day of December 2021, court via Zoom at 3:09 p.m. before the Honorable Sybil Williams, Justice Sybil Williams, Appellate Jurisdiction 2020, number 27, Dunjan Lamb versus the Queen. Mr. Lamb, Mr. Paul Wilson for Mr. Lamb, and Department of Prosecutions, Ms. Tweed for the Crown.
Okay, thank you. Sorry, who's for Mr. Lamb? Mr. Wilson, is it?
Mr. Wilson.
My lady.
My lady, before we proceed, I understand we have another matter of Terrencio Liu.
Yes.
In an effort to save the court's time, I have received instructions from my line of friend, Ms. Greening, who is present and has indicated that this matter will be given short. So I just.
Terrencio Liu?
Yes.
So you want me to deal with that first? All right. Miss Ashley, you don't have to formally call it. It's fine. It's okay. I have Terrencio Liu in front of me. And how is this being expedited?
Yes, good morning, good afternoon, milady.
Yes, thank you, Ms. Green.
Mr. Lowe here with me?
Yes, good afternoon, Mr. Lowe.
He was representing himself, you don't need to go. He was representing himself previously and filed an appeal. He's now taken some advice from me that that appeal will be abandoned and withdrawn.
Okay. All right.
Thank you. Just for the sake of completeness,
we will formally discharge it.
Yes, we'll be writing to the Magistrates Court to request his license back in under the relevant provision of the Offences Act.
Or formally dismiss it, sorry.
Thank you.
Formally dismiss appeal. Statement. Aaron, what you looking for? Oh, I see. She doesn't have to read all any more headings. This one. Yeah, that's fine. Just take up time. Trying to sorry, who was my prosecutor for that? Ms. Tweed?
Yes, my lady.
Thank you.
You're welcome.
All right, so appeal dismissed. Thank you. Thank you, Ms. Greening.
Thank you. I have one other matter before the court, so I'm not going to ask to be excused just yet.
Well, I am going to, ordinarily, I think I would recognize some seniority. I see Ms. Mulligan patiently waiting, and I have to say, it usually grates on me when the court doesn't give some recognition of seniority. So let me just get Ms. Mulligan's matter. Ms. Mulligan, what's your matter?
Hi, I'm actually holding for Ms. Christopher.
Yes.
It's a matter of Mr. Charlton.
Mr. Charlton. Okay. And then I'll come to your second matter, Ms. Greening, and then I will come back, I think, to the Dunjay Lamb matter, okay? All right, so Raymond Charlton.
I believe it's just here for directions for the appeal.
Mm-hmm. Does this have a date already, or?
No, it doesn't, as far as I'm aware.
Okay. And who's the prosecutor, Ms. Tweed? Is that you again?
By default, my lady.
Okay, are you holding for a particular prosecutor, or?
I didn't have it on my list today, but I'll hold it.
Okay. Yes, I think I can be the messenger here and just convey the apologies of the court. Obviously, the matters that were listed for the 9th of December were brought forward and counsel was not given proper notice. And I think phone calls went out very belatedly today. But that was either the court staff being overwhelmed, as they no doubt have been for some time now, or an oversight. But either way, I'm very sorry for any inconvenience it's caused to counsel.
Thank you.
So Rand Charlton. Do you know Miss Christopher's calendar? Do I know the prosecutor's calendar? I don't want to set a date if it defeats the whole purpose.
Yes, I have Miss Christopher's dates.
Okay, great. And Ms. Tweed, you will have some general idea as to what the Crohn's availability would be. It would just be the availability of the prosecutor, since this is just arguing an appeal. Well, first off, there's an application for leave to adduce fresh evidence. And that would be in the form of the affidavit that was sworn by Mr. Charlton on the 22nd of June earlier this year. Am I?
Yeah, I had spoken with Ms. Christopher about that. It seems unlikely that that application will proceed.
For fresh evidence?
Yeah.
Okay. All right. So we're looking at just argument then.
Yes.
Okay. Any of the proceedings have been stayed in the magistrate's court pending this appeal?
That's a good question. I don't believe that Mr. Charlton has been sentenced, but I could be wrong about that. I'm trying to, my memory is all I'm going on for that.
Is he on bail or has he been?
He's on bail. He's on bail. Well, he's on bail or he wasn't sentenced to custody. I'm sorry, I shouldn't say that. He was.
So he may have been sentenced? Was he sentenced?
He may have been, but I don't believe so. I don't believe he was. I believe that he is on.
So his sentence will have been stayed and
Yes.
he's on bail pending appeal.
That's what I believe. I apologize for not having more information.
No, I
could
think that's
potentially
understandable.
assist if I can just have a minute to look in our pre-law system.
Okay, thank you.
Thank you.
Doesn't appear to me that any sentence was passed. And so just by logic,
Yeah,
I
that's
would.
my recollection.
That sentence has been stayed pending appeal.
But that is correct. My lady, can you hear me?
Yes, very well, thank you.
Apologies. According to our note, it says matter stated that defense can appeal on the grounds of new evidence. I can confirm that the sentence has been stayed.
All right. Okay. I can hear this matter. That, what time did I set that last matter for the 7th?
Of January.
January. Oh, I set it for the morning. I should have set that for the afternoon, really. That was a short one, but. I'll set this for 2:30 p.m.
On
Friday, the 7th of January.
Okay. It's fine for Ms. Christopher.
Okay, thank you.
No, that's for the Crown.
So in terms of directions, let's get skeleton arguments from Ms. Christopher. Within, I can say 14 days, 14 days. We're coming into that Christmas season. I knew what that's like. But 14 days at least allows Ms. Christopher to skirt that. And then the 14 days thereafter is on the Crown. So I'll say 14 days, 14 days, yes? 14
Yes, my lady.
days, thank you. And prosecutor, 14 days thereafter. All right.
So I'm sorry, just so I have that straight, she's to file her skeleton within 14 days from now or 14 days
Yes, no, from today.
from
She's
today?
a representative of the appellant.
Okay.
All right. So that's it for the matter of Raymond Charlton. Thank you, Ms. Mulligan. Thank you, Mrs.
Thank you.
Tweed.
I might be excused.
Yes, thank you. And so who did I say? I was going to deal with Ms. Greening's next matter, which is, are you Lencia Barkley?
Yes,
Yes.
Melody.
Okay. So let's see.
Ordinarily, it's Mr. Richards for the DPP that has conduct of this matter for the respondent. I'm not sure if Ms. Tweed is holding. It looks like she might be.
I'll gladly hear it on behalf of Mr. Richards this afternoon.
The history of this matter is that Miss Berkeley was convicted in the magistrate's court and filed an appeal. Further to filing the appeal, her position laid out in her first affidavit dated the 20th of July, 2021, is that a consent order signed on her behalf by her lawyer and the prosecutor was filed to abandon that appeal without any knowledge to her. She then came to me and instructed me to make an application to vacate that.
Oh, yes, I remember this.
And I was asked by you, my lady, a long time ago to file an affidavit, which I did in July, or for my client to file an affidavit laying out why she would like or why she thinks she has grounds to vacate the abandonment. She has done that by way of her first affidavit and supporting exhibit. And at that time, there was no order for the respondent to reply because her ladyship said she would consider the affidavit of the intendant appellant and then take it from there.
Yes.
In our respectful submission, my client has laid out good grounds to vacate the abandonment. The crux of the matter in one sentence is that she had no knowledge of the consent order. If that is not disputed or if it's accepted, then in my respectful.
Well, it looks like a very compelling case to set aside my conditional order of dismissal. Anything you want to add to that, Ms. Tweed?
Not at this time, my lady.
Okay, so I set it aside and I'm getting to know if it's a date for the hearing of the appeal.
I am in receipt of the record. Thank you to Mr. Richards. And so then I'll go ahead and order the court smart recording and prepare for appeal.
Thank you.
Thank you.
So now I probably, should I set down a date now, or should I just mention this again on another date?
Milady, there is a date set in the diary already for the 9th of December. It's very soon. So it's
9th of December for this?
It's not likely we'll be prepared in time.
No.
But
and I believe Mr. Richards is out as well.
That would also need to be vacated.
Yes. I don't remember seeing that. Let's see. I don't have this on my list for 9th of December. I have Michael Richardson appeal at 2:30. I don't know if you know anything about that, Ms. Tweed. And civil matters in the morning. I don't know anything about this. Oh, wait a minute, that 9th of December date would have just simply been to do what we're doing now for directions.
Yes.
Okay, so that's, yeah, that wasn't for the hearing of the appeal. My question to you is whether or not you'll be in a position for the hearing of this appeal by, because I can either mention this in my list for the 1st of February, or I can set a hearing date before that. And I'm just trying to get some sense as to where we are time-wise.
Well, my client is very mindful of costs given her history.
I can't hear you, sorry.
My client is very mindful of costs given the history.
Mhm.
And so I mentioned, unless the Crown has good reason for one, is
Well,
not
then
necessary.
I'll have to set a date now, because the purpose of the mention will be to set a date. I can either set a date now, or I can wait till February, set a date when you can confirm where you are.
We'll just take a date, please, and
All right.
file submission 3 days before the hearing. Thank you.
I'll give you directions in a moment.
Well, we have to file grounds. Start from the beginning.
I can set this matter done for Thursday, the 6th of January. Yes,
Your worship, the Crown, that works for the Crown.
sorry?
That works for the Crown, your worship.
Okay. So,
I was in court this morning with Mr. Richards, and it didn't seem that he was available in January, or did I get that wrong?
I understand that he's out for the month of December. I can just confirm, he just give me 1 minute.
okay.
I gotta go and pick up.
Apologies for the delay, my lady. I can confirm that the 6th is convenient for the Crown.
Okay, thank you. So now let's deal with directions.
And you said,
Um,
my lady,
Sorry,
2:30 on the 6th?
on the 6th at, yes, at 2:30, thank you.
I'm good.
Appeal.
Oh, she,
So I would like to see scouts and arguments from the appellant in the next 14 days. And 14 days thereafter from the respondent. All right.
yes,
1st of December. And that hearing, as all the other hearings have been proceeding, will be by Zoom. Live streamed, okay?
at 9:30, milady,
No, at 2:30 p.m.
at 2:30. Thank you. Do you need me to put the order together?
I don't usually have orders perfected for the appeal matters. They're usually pretty standard, 14 days, and then a date set, so that's fine. I won't add to anyone's plate. All right.
Those are my three matters. May I be excused?
Yes, thank you very much, Ms. Greening. So now I think I can hold my final matter, which is Dunjay Lamb.
Yes, my lady.
Ms. Oswald, are you making those entries in the calendar? I don't want to, those dates.
Haven't, but I intend to in a moment.
Okay, no, I've just made 1 or 2. I just don't want to be doing it over you. I'm just trying to get them in quickly so that I can see what's available for each matter as it comes up next. Even if you just put a blank box in so I can see what slots are taken, please. Yes, Mr. Wilson and Ms. Tweed. So we have, you are appearing for Mr. Lamb, Mr. Wilson?
Yes, ma'am.
Okay.
Is he present?
I think the
sorry?
question was whether or not Mr. Lamb is present.
No, Mr. Lamb is not present. He's not.
Okay.
with me.
I have to say I'm somewhat sympathetic to, is this one of those matters that was brought forward from the 9th of December?
Yes.
Mr. Wilson, I'm struggling to hear you.
Well,
No,
I think all you have to do is raise your voice.
my lady, can you hear me now?
Yes.
Okay.
my lady, this matter was due to be heard on the 3rd of November, but it was delisted and rescheduled for the 1st today.
Ah, okay. But it was administratively delisted.
That is correct, my lady.
Okay. And Mr. Wilson, although your client is not here now, whenever I do set the date down for the hearing of the appeal, I think you will already appreciate your client, Mr. Lamb, will have to be present.
Yes, ma'am.
Okay.
Oh, I'm sorry, I thought today was the actual appeal.
No, every month at 2:30 p.m. on the 1st of each month, I list out all of my criminal matters. So there is no matter that's going to be argued substantively on the 1st of the month in any criminal matter before me. I can tell you that.
I'm guarded, my lady.
Yeah, this is just literally the last matter on my list. I'm going to give it a date now.
I'm guarded.
All right. But you did answer what would have been my first question, and that is that this matter is ready for listing. Have arguments already been filed? If it was listed, so everything's
ma'am.
already before me.
Yes,
So we've got
ma'am.
arguments from the respondent, and I have the bundle that you would have filed, Mr. Wilson, which has presumably on the top of it your skeleton arguments.
Yes, ma'am.
I don't see your skeleton arguments just yet.
They should be in there, my lady.
I see the green. Oh, I see, it's at the back.
Tab
Is that
two,
tab
my
two?
lady.
Thank you. All right. If I can just give this a date. Sorry, Gina, still looking for those boxes in the calendar. Is there, I just gave an afternoon slot for 2:30, right?
Yes.
That was on the 6th of January, my lady, for the last one that you gave.
6th and 7th. Yeah, I just, so am I correct, Ms. Oswald, that the morning fixture for the 6th of January is open to me?
That's not going to work for the Crown in any event, my lady. I would-
Okay, thank you. That was short.
Yeah.
All
I
right.
will be on
What
vacation.
type of
I
date are
will
you
be-
looking for?
I'm due back in office the 10th, but I do have an assigned matter.
Okay,
Anytime after that, I will be grateful.
after the 10th of January?
Yes, please, my lady.
All right, well, that takes us out of January because I have, I'm going to try and keep, let's see. All right, let me squeeze this in. I can give you Wednesday, the 12th of January.
That works for the Crown. my lady.
Yep, Mr. Wilson?
Yes, my lady, that's fine.
Okay, Wednesday, the 12th of January, and I'll put that down for 2:30 PM.
I'm grateful.
Okay,
Thank you, my lady.
yes. No, same directions, 14 days each for scouts and arguments. No, I don't need to do that. Yeah,
Everything's
scouts and
been fine.
arguments, sorry. All right, so it's as simple as that. You just wanted a date. And I have one. Thank you very much.
Good.
Make
Thank
sure
you.
your client's here on that date, please, Mr.
Yes,
Wilson.
will do.
All right, thank you.
Thank you, my lady.
Okay, I will adjourn. It's my last matter. I don't know. I see. Oh, is that the World Gazette? Okay, I thought that was another lawyer. All right, that's fine. Thank you.
Thank you.
And I adjourn for the day. Thank you very much.
All right, bye.